Hello, everyone. When you start to read your contract, and hopefully you aren't doing this for the first time after signing it, and you run across restrictive clauses, what do you think? Is there anything I could do about this? Even if I bargain, they just won't budge. My name is Premkiranreddy, founding attorney of Reddy's law firm. In this series of short videos, I will lean on my training and experience in both the medical and legal fields to answer these questions. So let's talk about those bothersome restrictive clauses. These could be non-compete clauses and no solicitation clauses. First, see if this is even legal in your jurisdiction or state. Second, if legal, see if it is reasonable. Third, even if it is reasonable, bargain to lower those restrictions. Let us talk about the first point now. See if it is even legal. Some states like California have statutory restrictions on using such restrictive clauses. So if it is not legal and no exception applies, end of story. Tell them it is unenforceable and to strike it off. In states like Texas, such clauses may be allowed only under limited conditions. Other states might allow such restrictive clauses more liberally. For sale of business, courts give extra leeway for enforcing restrictive clauses. Now, second, if legal, is it reasonable? Meaning, is the clause used to protect a legitimate business interest? Courts may see if the employer is protecting some proprietary business interest and may enforce such restrictions, perhaps if it is narrowly tailored, that is, not greater than reasonably necessary to protect the legitimate interest. So, when you negotiate, show them that there is no trade secret or confidential information to be protected, or that the method that they use is causing you undue burden and is more restrictive than necessary, and alternative feasible methods do exist. Courts may see if the employer invested some unique specialized training in you. The employer may be justified to restrict you from leaving if it gives the competitor an unfair advantage for what the employer has invested in you. Courts may see if there is goodwill created between the employer and their patients that they don't want to lose. But even here, you can argue that the patients aren't owned by anyone, as this is against public policy. You may also show its undue burden on you and that it is not narrowly tailored as we saw earlier. Other public factor considerations courts may consider are whether a monopoly is created, if patients can still continue care, if there will be a shortage of doctors, or if other employment opportunities outside the area even exist. Now, if the restriction was added on after the initial contract, and the employer did not give anything in exchange like more salary, then there may be no bargain for exchange and hence no valid consideration and not enforceable. Now, third, even if legal and reasonable, bargain to lower the restrictions. If the restriction is, say, a 10-mile radius, bargain to 3. If the restriction is for 5 years, bargain to 2. If you are in a rural area, 10 miles may be reasonable, but in a metropolitan medical center, there are already so many other competitors right there. It is hard to justify that same 10-mile restriction. Also, find out if you can be released from this restriction in case of a buyout or a merger of the company. To recap, if the restrictive clause is illegal, have it stricken off. If it is reasonable, see if the method used is least restrictive and protects some legitimate interest, unique training given, or goodwill. If not, have it stricken off or modified to make it reasonable. And even if it is reasonable, negotiate to get it as low as possible. Remember, If you have another contract in hand, or you know the norms and laws in your area, you can negotiate better. Seek legal guidance if necessary, but know the current laws in your jurisdiction. Please be also on the lookout for my series of videos on other various topics including contracts, ethics, health law, and dispute resolution. Thank you for watching and hope to see you soon in the next video. Bye.